The three-judge special bench of the Supreme Court, which was led by Chief Justice of India, Sanjeev Khanna, has made three important decisions today. It has remarked that there will not be any suits that will be entertained in the court of law when it comes to disputing the religious character of a place of worship until and unless the Supreme Court then hears the case and passes a verdict in the Places of Worship Act 1991. The second important decision that has been made by court today, it has asked all courts across the country to not pass any judgments or give any orders, including conducting of any surveys in any places of religious importance, of any place of worship in the country, till the time the case is undertaken by the court in the Supreme Court. It is important to note that there are at least 18 of these lawsuits that are pending in courts across the country, which concern as many as 10 mosques. The number 3 decision that has been made by the Supreme Court today is to ask the central government to file an affidavit, and it has given it 4 weeks' time. This affidavit is going to be filed in response to the challenges that have been put out in the court of law, in the Supreme Court, in terms of the suits that have been filed. And these suits are questioning, are challenging the very validity and the provisions of the Places of Worship Act 1991. Now, since there's a lot of commotion about the Places of Worship Act, let's try to understand and break up what exactly was this act that was passed in 1991, that was enacted by the Parliament in 1991. Now, it was in 1991 under the Prime Ministership of P.V. Narasimha Rao that this act got enacted. As per the act, it freezes the religious character of a place, which means that up until 15th of August 1947, there can be no action taken by any court of law or any amendment in the Parliament that will change the religious character of that place, which means that there can be no demolition that can take place at a religious site and another structure of another religion be erected on top of it. This was, of course, an exception to the Babri Masjid Ram Janmabhoomi dispute site that obviously saw the culmination after there was a verdict that was passed in favor of the Ram Janmabhoomi side. And there was, of course, Ayodhya Ram Temple that was built. Now, taking a look at the 3 important sections under the Places of Worship Act 1991. Number 1, which was Section 3, which prohibited any individual to change the religious character of a particular place of worship, which means a particular place of worship could not be demolished and another religious site could not be erected on the ruins of that particular religious site, and this was negated, this was prohibited by this act. Number 2, the act also mentioned that once the commencement of this particular act that was passed, that was enacted in 1991, all suits, all petitions that were put in the court of law would cease to exist. And number 3, which was Section 6, mentioned that if there was any violation of Section 3 of this act, there would be a punishment that would include 3 years in jail and fine that will have to be paid by the violator. Now, there were a number of challenges that this enactment in the Parliament faced. There were a slew of petitioners which were led by the then BJP leader Subramanian Swamy, who challenged this act in the court of law. The number 1 reason for challenging this act in the court of law, as per the petitioners, as per the lawyers who fought the case, was they claimed that this act in fact was a violation of the fundamental right of every citizen in the country, which was the right to equality. It also questioned about the violation of Article 25 of the Constitution, which was the right to religion for every citizen in the country. There were other of these claims that were made, which questioned and said that the act actually created an arbitrary and retrospective act of picking a date, which was 15th of August 1947, in deciding to say that this was the date after which there is not going to be any change in the religious character of a place of worship. They said that this was against the encroachment that was done for decades together in the past, before 15th of August 1947, by fundamentalist invaders that entered the country and demolished hundreds and thousands of temples and erected mosques in their place. The petitions that were filed by these lawyers also mentioned that the parliament could not stop Hindus from staking claim to their original site of worship, place of worship, by way of taking judicial recourse. Now, there has been a lot of criticism that has also come by way of people questioning that if this particular act was rolled back, if it was abrogated, it would cause mayhem and chaos across the country. There would be instances of religious disharmony, communal disharmony. It would disturb and adversely impact the religious fabric, the secular fabric, in fact, the very syncretic culture of our country. There would be, in fact, it would open a Pandora's box, as we have seen recently in the past. There have been disputes, there have been cases, there have been petitioners who have been asking for surveys to be conducted at the site of mosques, whether it is the Varanasi site where we're talking about the Kashi Vishwanath Gyanvapi dispute that is taking place, or we're talking about the Mathura site where we see the Shahi Idgah and the Krishna Janmabhoomi dispute that has continued for months together now. The latest one, unfortunate case where 12 of those people died in the riots in Sambal in Uttar Pradesh. Another mosque was brought into contention because the local court decided to pass an order for a survey to be conducted on that piece of land, which was a mosque that was built several decades ago. Now, there was, ever since this petition that was filed challenging this act, the Places of Worship Act, which was filed in 2021, and in 2022, the case was heard in the court of law. This was heard in the Supreme Court by the then Chief Justice of India, which was Justice D.Y. Chandrachud. Now, he remarked, making an observation in the case, that there was no harm in the petitioners to go to court and seek a survey to be conducted at a place of worship to find out what the religious character of that place of worship was, on the condition that the intent is not to change the religious character of that place of worship. Now, that brings me to the question about this very sensitive, controversial issue that has taken the country by storm. The question I ask is that, is there really actually a need to stir the hornet's nest? Because there have been past instances about Hindu-Muslim communal riots, communal disharmony that have plagued the country. Also, if we keep looking for temples under mosques and then reach out to the courts with the intent of rebuilding these temples and destroying the mosques or other religious structures and build temples atop them, are we not then destroying the hundreds and hundreds of years of history that has been built, whether it was about the Hindu rulers or the Islamic rulers that came into force, the Mughal era, and then of course the British era? The third question that arises is that what is the intention of these individuals or organizations that claim themselves to be the custodians of Hindu religion, of Hindus across the globe, when they come out and stake claim and say that We demand a survey be conducted, and then after the survey is conducted, and if it is found out that there was in fact a Hindu temple that had been destroyed to build that mosque, then remove the mosque, raze it down, and rebuild that temple. Will this not agitate the Muslim community in the country? And then, most importantly, is it not correct to say that if the Places of Worship Act 1991 is abrogated, will this not amount to an anti-Muslim act, an anti-Muslim sentiment that will spread across the country?
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.